Hello, fellow targeted individuals. My name is Edwin Jones. I'm from Indianapolis, Indiana. And this is part 2 of proof of police, prosecutorial, and judicial misconduct. And what we will be discussing is my fake affidavit for probable cause that you see right here in front of you. This is especially for targeted individuals who have been wrongfully arrested and are convicted of a crime, who choose to fight instead of accepting their conviction or a plea bargain that they agreed to. This is a probable cause affidavit that you have a constitutional right to request from your attorney. The request is made in the form of discovery. Ask for your entire discovery, and every state and the federal law requires that your attorney give you that discovery. Now, after my attorney, Ali Talib, turned it over to me, he just arbitrarily quit. And here's why. When I was incarcerated, he visited me and told me that, oh boy, she was lying. Her story is so full of holes. And I said, yeah, I know that I'm innocent, but why am I here? I'm going to sue. And that was my mistake, because immediately after that, he changed his attitude and started asking questions designed to make me feel confused, designed to implicate me. And that's when I stopped trusting him. Up until then, he was a friend who represented me in several civil cases. Now, probably everybody knows what an affidavit is, but let me give you an example of how affidavits are done. If you've ever made out a will, then you know that a will requires witnesses to sign in the presence of a notary public that all statements are true. Then the notary public puts their seal on it and signs it, verifying that information. The police practice with everybody, throwing a lot of official-looking papers in your face to get you to plea bargain. They make you feel like you can't win. And I'm going to show you how to protect yourself, primarily from your own lawyer, as well as the police and judge and prosecutor. Now, I have 4 points to make, and I'll try to make them quickly. The first point is that Indiana Code 35-33-5-2, Section 2A, 1 and 2, states that an affidavit for probable cause is the only standard by which further criminal action is merited. In other words, if the affidavit is wrong or fraudulent, then the search and everything else and the fruits of those searches is going to be unconstitutional. Okay, affidavits, and it goes on to say the affidavit or statement of probable cause must be such that action for damages or charge of perjury may be predicated upon, if untrue. And I tried to sue, but they threw my lawsuits in the trash. And we'll get to that later. That was Wallace versus State, 1927. So the law's been around for a pretty good while. And the police had collective knowledge of the contradictions and fallacies of this report. It is against your constitutional rights to be subjected to an arrest and detention without probable cause based on charges procured by perjured testimony. And in my case, the perjured testimony came from not only the so-called witness, from Katie, but also with assistance from the judge and a judge and a prosecutor. I went to college with the judge, Z. Jemison, but we'll get to that later. Point number 2 is, in addition, and I'm reading, in addition, a judicial determination of probable cause upon which to issue a search warrant is required. And a warrant may issue only upon evidence which would be competent at trial or offense before a jury and would lead a man of prudence to believe that the offense had been committed. So what they're saying is that a warrant must stand or fall solely on the contents of the affidavit for probable cause. So this is the beginning of all criminal action. And as you can see, where I've got circled, there's supposed to be a signature of a judge there. That's your constitutional right also. And I suggest, I implore you to read through the affidavit for probable cause. That's the second point. The third point, which is the most important point, is that the affidavit for probable cause was signed by just a detective, Robert Flack, and a prosecuting attorney, Maureen Donahue, who's now a judge. And the line reserved for judge was left blank and unsigned. Now here's the law, state and federal. Affidavits for probable cause must be signed and sworn to in the presence of a judge. They must be signed and sworn to in the presence of a judge. That's Indiana Code 35-33-5-2, or a neutral magistrate. And obviously the conflict of interest is pretty clear, because the detective wants to arrest you and the prosecuting attorney wants to convict you. My last point, because I'm trying to make these videos as short as possible, because there are many more to come. The last point is that the Indiana and the federal Constitution Bill of Rights, Article 1, Section 11, and the U.S. Constitution Amendment 4 mandates that no warrant shall issue but upon probable cause supported by oath or affirmation. It goes on to say that the Fourth Amendment would become a nullity and would leave privacy to police discretion if judgments relative to the sufficiency of the cause to conduct a search or an arrest were left to other than neutral and detached magistrates. Now that's pretty fantastic. That ends the affidavit for probable cause. I hope you've learned something, and I hope that you can use this to help yourself or to help someone else. Thank you very much.